Judge, we're ready for Mr. Adams. Let's go ahead and
Yes.
Did I really?
I think. You want her to come up? Thank you.
Mr. Adams, can you hear me?
Yes, Your Honor, just fine.
All right, that's some kind of issue over here. All right, this is State versus Josie Bohannon. This is cause number CR 22-2. Go ahead, Mr. Adams.
Afternoon, Your Honor. Mitch Adams on behalf of Ms. Bohannon for record purposes. Your Honor, I have the printed discovery materials in this case. I was notified last week by the DA's office that the audio visual materials are available. I have not yet had the opportunity to pick those up. I will do so after our hearing today. In reviewing the materials I do have, I thought I might have there's a possibility there may be an evidentiary suppression issue here that I could argue. So I went ahead and filed a motion to suppress today or earlier today. That probably hasn't made it to into your hands or to the state's hands yet. I went ahead and did it out of an abundance of caution, just to have it ready in case what I see in the video doesn't dissuade me from proceeding with that. Ms. Bohannon is currently on deferred adjudication probation in Smith County. There is a motion to on file in that case, and there is a blue warrant for her from Smith County. It's a no bond warrant. Smith County, of course, being Smith County, doesn't set bonds on those. At any rate, I guess that's a long-winded way of asking the court to set us for another pretrial hearing so I can get a copy of that video material, review it in conjunction with the printed material, and see how to proceed or whether to proceed on the suppression issue that may or may not exist.
State objection.
Judge, state would have no objection. I do believe that the clerk emailed me a copy of the motion to suppress just because it was set today. I have not had a chance to review it, but we do need to get Mr. Adams his discovery. I am aware it is ready, but we need Mr. Adams to have it and review it, but we would be unopposed.
All right, you said Mr. Irvin for an additional pretrial hearing. Are you available on December 15th, Mr. Adams?
Yes, Your Honor.
All right, court sets Ms. Bohannon for pretrial December 15th at 1:30 if she's in custody, 9 a.m. if she's not.
Yes, sir. All right, Your Honor. That concludes my announcement in this case. I don't have anything else on your docket today, to my knowledge. May I be excused?
Yes, sir. I believe that's all.
Thank you. Nice to see you. Yeah.
I'm ready to, but I've got mine's a plea though. I just gotta. Yeah. Knock yours out.
Yeah. Okay, I was just, all right, let's check.
Mr. Schmidt, who are you ready on?
Michelle Lynn Daly.
All right, court called CR 14460. I bet it's a write-in. And they added one offer. Michelle Daly, D-A-I-L-A-Y, add on.
Yes.
Motion to revoke. Go ahead, Mr. Schmidt.
Judge, the state is, and I've got in my hand a motion to withdraw their MTA and to continue. Or actually, this is terminate community supervision. I need to make sure that Ms. Heisel is aware of that.
Did I circle the wrong one?
Well, it's motion to withdraw, state's motion to revoke and terminate community supervision. I believe we intended.
There should be, right above, the order, there should be 3 options with 1 circled. If not, I will get that corrected and get it to the courthouse.
Okay, and if I could, can you see?
Yes, so I have continued circle there.
Oh, I don't have my glasses on. Okay. We need to change the title of the document because it says terminate.
Fair enough.
But if we're going to continue and place her back on probation, Ms. Daly was arrested for the offense, which triggered the motion to revoke, and I believe the state's rejected that case. And we'd ask the court to approve that.
Okay, is there any amendments to our conditions of community supervision, or is just withdraw the motion and we're back?
Your Honor, I believe she already had some sanctions. However, at this time, we're not adding those to the conditions. The basis, the overwhelming weight of the state's MTA was that new offense, which has been rejected by our office for prosecution. So we think it's in the interest of justice to put her back on. I know she was a little bit behind, but I believe she still has 3 years remaining. The probation department indicated to me that they thought that she had time to comply with the additional terms of her originally ordered community supervision.
Okay, grant the state's motion to withdraw, motion to revoke. Court will continue Ms. Daly on her previous court-ordered community supervision.
Thank you.
You died. Okay.
I want to do the females first.
No, that's what. Oh, yeah.
Joanna, are you ready on Ms. Mormon?
Yes, very ready.
All right, Ms. Mormon, CR 16139, State versus Polly, Elise Mormon. What's the announcement today?
I'm sorry, Judge, which second?
What's the announcement today?
Oh, we're ready to execute a plea.
Okay.
Well,
All right, what are the terms of the plea?
yes, Your Honor. It was a motion to revoke her probation. It was abandoned and endangering a child by criminal negligence, state jail felony. She's being sentenced to 180 days in jail with 180 days credit. She served more than that, I believe. She's been in custody in Smith County and she was bench warranted from Plains State. So she also owes the remainder of her financials, which is $1,208. And she's going to plead true to all accounts in the motion to proceed. I think that's it, Judge.
Okay, thanks. And is the state proceeding on the motion to adjudicate file on October 1st, 2020, or has it been amended since then?
The one that we have, Judge, is October 1st, 2020. And then honestly, we've been not at fault of Miss Mormon, but just kind of chasing her from Smith County. I think they denied a bench warrant once, if I recall. And then she got, shipped down to Plain State. So we've been trying to get this done for probably over a year. So it is, yes, Your Honor, to answer your question, it would be, it was the one that was filed on October 1st of 2020.
Ms. Mormon, if you will, please, ma'am, raise your right hand. I place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand. Just make sure you speak up loudly and clearly for me, so one, that I can hear you, and two, so my court reporter who's present with me in the courtroom can take down what you have to say, okay?
Yes, Your Honor.
All right. Ms. Mormon, let's see here. Pull up your motion. Ms. Mormon, it appears that you appeared before the court on March 12th of 2019. You pled guilty to the offense of abandoning or endangering a child with criminal negligence, a state jail felony. Court heard the evidence on that date, found that there was enough evidence to convict you, but the court followed a plea agreement in your case, and the court deferred a finding of guilt and placed you on community supervision for a period of 3 years. The court also ordered you to pay a $1,500 fine. It was during your period of community supervision that the state has filed its motion to adjudicate and revoke on October 1st of 2020. In this motion, the state has alleged in 8 separate counts ways that they believe you have violated your community supervision. Have you had enough time to review this motion with your attorney, Mr. Weiner?
Yes, Your Honor.
You feel like you've had enough time to talk with him about this and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, Your Honor.
And where you have signed in the paperwork, you're telling me that that is your true and correct signature, and you only signed once you were confident you knew what you were signing.
Yes, Your Honor.
And Mr. Weiner, do you believe Ms. Mormon to be competent to enter into this plea agreement today?
I do, Your Honor.
And you've explained to her her rights with regards to this motion,
I have, Judge.
and you believe she understands those rights?
Yes, Your Honor.
And is she going to be pleading true to all 8 counts? And does she waive the formal reading of the state's motion to adjudicate?
Yes, both questions, Judge, would waive formal reading.
All right, Ms. Mormon, at this time, I'm going to ask you, I'm having, for the record, I'm having this displayed to you via Zoom. How do you plead to counts 1, 2, 3, 4, 5, 6, 7, and 8? Are those counts true or not true?
True.
And Ms. Mormon, are you telling me that those counts are true because in fact what's alleged in those counts is in fact true? You're not just saying that to get a plea agreement?
Yes, Your Honor.
All right. And Ms. Mormon, has anyone threatened you, forced you, pressured you to make you feel like you had to plead true today?
No, Your Honor.
All right. The court will accept the defendant's pleas of true to each count as alleged. Mr. Weiner, any objection to the admission of the defendant's waiver of rights and plea of true?
No, Your Honor. We've previously received, reviewed, and have no objection to the state's offer.
All right, then the state's evidence is admitted and the court takes judicial notice of Ms. Mormon's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Not regarding the plea, Judge.
Okay. All right, Ms. Mormon, then based on the evidence presented to the court today, the court finds that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement in your case. The court hereby adjudicates your guilt, convicts you of abandoning or endangering a child with criminal negligence, a state jail felony. The court will revoke your community supervision today and assess your punishment at 180 days confinement in the Van Zandt County Jail. Court will issue you credit towards that sentence for 180 days. Court will order you to pay the balance of your financial obligations. when you are released from TDC, then it's important that you report to the Van Zandt County Courthouse and speak with a court compliance officer to make arrangements so that you can discharge what you owe the county in this case, so that a warrant is not subsequently issued for your arrest. Do you understand?
Yes, Your Honor.
All right. Ms. Mormon, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Good luck to you.
There is one just housekeeping matter, Judge, and I'm probably overkill here. But for some reason, I mean, there's been a hold from Van Zandt County for this charge on her before. But for some reason, there's an outstanding warrant for her for this particular charge. It's my understanding by executing this plea bargain, that warrant would be extinguished or withdrawn. I just don't want to do anything to trip her up. She's time served on this, but she still has, she's serving a state jail sentence out of Smith County. She should be released on November 30th. So I just want to make the court aware that, you know, when we started this plea, she had an active warrant for this charge. I just want to make sure there wasn't anything that we need to do to alleviate that.
No, the court is aware that the court found her bail to be insufficient back in April of this year. And Deputy Everett has brought that to my attention, and it's going to be my, what I'm going to do is order that to be withdrawn based on her plea today.
Thank you so much, Judge. All right, that's all I have. May I be excused?
Yes, sir.
Thank you. You're good. Spin around. Shadow numbers and stuff. December 1st.
All right, Mr. Schmidt, who are you ready on?
Austin Hensley.
Mr. Hensley, CR 22-274. Mr. Hensley is to enter a plea today, is that correct?
That's correct, Judge.
Can you tell me the terms of the plea, Mr. Schmidt?
Yes, actually, the state's recommending that upon a plea of guilty, the court defer a finding of guilt. Put Mr. Hensley on community supervision for a period of 6 years. Assess $1,000 fine. In addition to that, he is to submit himself to safety as a condition. The state has also agreed to take into consideration a unfiled VA 2022-0792 under 1245 of Texas Penal Code. $290 in court costs, $515 in reimbursement fees.
Any restitution?
There is none listed on here, Judge.
No, Your Honor, there's no restitution requested.
All right, Mr. Hensley, raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, you can lower your hand. All right, your name is Austin Keith Hensley, is that right?
Yes, sir.
And Mr. Hensley, are you a United States citizen who does read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
What have you been diagnosed with?
PTSD.
Are you currently under doctor's care or medication for PTSD?
No, sir.
Do you feel like you have a rational understanding of the proceedings that have gone on in this case, including today?
Yes, sir.
Now, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir, I do.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe that Mr. Hensley is competent to enter into this plea?
I do.
And you've explained to him his rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
And do you think he fully understands both?
I believe so.
And Mr. Hensley, you heard Mr. Schmidt read to me what your plea agreement is. Is that what your understanding of the plea agreement is?
Yes, sir.
Can you tell me in your own words what would happen with the plea agreement? Can you kind of tell me what deferred adjudication means?
Means that if I mess up, then I get, if I do good, then everything's set straight, and if I don't, it's just, I can catch worse charge.
If I approve this plea today, you would be pleading guilty to I'm assuming second-degree felony assault of a peace officer or judge. And the court would not convict you. Court would review you would plead guilty. The court would review the evidence. And if I find enough evidence to support the plea today, then the court would defer a finding of guilt. That means I would not convict you. I would give you the opportunity to be on community supervision for 6 years. And during that 6 years, if you complete the whole term without any violations that result in a motion being filed in the court, then the case could be dismissed. Understand that?
Yes, sir.
On the other hand, if you violate any of the terms and conditions of your community supervision, you understand that the prosecutors could file a motion to adjudicate your guilt. That means to convict you, and they could bring you back to court and put on evidence. And if they prove their case, they could ask the court to convict you of that offense, make you a convicted felon, and they could ask the court to sentence you in prison from a minimum 2 years all the way up to a maximum 20 years. You understand that?
Sir.
And that is the range of punishment for that charge, a minimum 2 to a maximum 20. Understanding all of that, you still wish to go forward?
Yes, sir.
Okay. Then, Mr. Hensley, I'm going to ask you, how do you plead to assault of a peace officer or judge, a second-degree felony?
Guilty.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
The court accepts Mr. Hensley's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, briefly, I've spoken to the victim in this charge. He is aware of our recommended plea. He is comfortable with it. And we would ask that the court follows the plea agreement, and we would rest and close.
Thank you, Mr. Woodward. Anything further from the defense?
Nothing further, Judge.
All right, Mr. Woodward, can you give me the facts that support the plea?
Yes, Your Honor, on 5/31 of this year, the victim, who is Officer Jacob Smith with the Canton Police Department, responds to a bank here in Canton where the defendant is making threats to staff and himself. He is clearly intoxicated. The defendant has blood streaming down his face from where he has struck his head against appears to be a wall. The officers go to detain him for officer safety and his own safety. He attempts to walk into traffic. They go to restrain him, and he bites Officer Smith's hand while resisting arrest. The defendant is tased and is taken into custody at that point. He is apologetic at that time and is taken, I believe, into custody.
Thank you, Mr. Woodward. All right, then based on the evidence presented, the court will find that there is sufficient evidence to convict Mr. Hensley of this offense. The court will follow the plea agreement and on the recommendation of the state of Texas. Court will hereby defer a finding of guilt, place Mr. Hensley on 6 years community supervision, order him to pay a $1,000 fine, $290 court cost, $515 reimbursement fees. The court will dismiss cause number 2022-793 under section 1245, and the court will order Mr. Hensley to attend the substance abuse felony punishment facility, also in the safety, as a condition of his community supervision. Mr. Hensley, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of your sentence. Go back to you.
Judge, just for the record, that is evading arrest, is what that charge is. I don't believe it was ever relayed to the court. It is evading arrest misdemeanor.
The 2022-792.
Yes, Your Honor.
Thank you, sir.
Judge, you want to wait on Ms. Plinter?
Yeah, whoever's next.
Well, is Bill Stevens going to appear by Zoom?
No, I think Mr. Stevens indicated to Ms. Taberham he was going to try to appear, but I think she's trying to get to the bottom of that. I'm not sure, honestly.
You just want to hold her up till the end?
Do we have anyone else? Yeah, let's wait. Let's wait. And as soon as I hear more on Mr. Stevens, I'll let you know. So we'll just hold her off till the end. You ready, Mr. Manning?
Yes, Judge. Sure.
All right, you said Shelton, correct?
Yes, Judge.
All right, CR 2278, State versus Jeremy Tremaine Shelton for arraignment.
Judge, his name is spelled correctly. He understands the charge against him. He understands the range of punishment is a state jail right now. And he pleads not guilty to this case. Request to be set for pretrial.
All right, court will find that Mr. Shelton has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record and set him for pretrial hearing. Do you want that December 15th date, or do you need January 5th, Mr. Manning?
Judge, if we had the shorter date, I believe we're close to an agreement. I need to speak to my client tomorrow, but I think we may be able to get some worked out.
Okay, court sets him 12:15. It would be at 1:30 if he's in jail, 9 a.m. if he is on bail.
Yes, Judge. Please, I'll see you tomorrow. Okay, see you. Mr. Penegua?
All right, Mr. Penegua, CR 22-245.
Judge, we're gonna be requesting a contested setting. I have a motion to suppress, so I need to file. I have not filed it yet. I was waiting to pick up the DVDs. The state has made me aware that those DVDs were available at the end of last month, but I have not got a chance to review those. We request to be set on the next contested docket.
Would you have to follow the motion?
Not yet, Judge. It's gonna be a suppression of the search and the evidence.
So you're at a position now that you know that you're gonna file a motion, but you haven't seen the video.
Absent seeing something contrary in the video based on what I've seen in the reports as well as my clients' discussions, we're gonna file the motion to suppress unless there's something that clearly controverts that on the video.
All right, court will set Mr. Penegua for November 29th. That'll be at 1:30.
And Judge, the last one I have is Mr. Bird, Zachary Bird. My understanding was that last we checked, he was in Rockwell County when I called to set up a meeting to go over his discovery. He had been moved to TDC. I have not been able to confirm his status in TDC as of yet, because they had just shipped him off, but my understanding is he is in TDC at this time.
My note says he's in the Bird unit with a projected release date of September 11th of 27. So I'll need to know if the state wants to go forward with a bench warrant, or if the defense wants a bench warrant.
Judge, if we could set that for a status, if we could give Mr. Manning I believe he's on the 12:15. The state will evaluate this case and see if it's something we need to proceed on, or if it's something we can resolve because he is in TDC custody for the foreseeable future. And if not, we will be able to apprise the court on that date of whether we need to bench him back or not.
Mr. Manning?
Judge, I'm fine with that.
Okay. All right, court will set Mr. Zachary Bird for status on bench warrant request for December 15th.
Judge, I believe that's all I have, and please be excused.
Yes, sir. I think that's all you've got.
Thank you, Judge.
Thanks, Shane. All right, Mr. White, you ready?
Yes, sir.
All right, this is cause number CR 2356, State versus Michael Thomas Ringgold. And it's my understanding from counsel that the state has already submitted to the court a motion to withdraw the state's motion to adjudicate guilt. The state is asking the court to continue Mr. Ringgold on community supervision with a modification to include Mr. Ringgold going to safety. Is that correct, Mr. White?
Yes, sir, that's correct. We signed the addendum and the modification, and I'm satisfied Mr. Ringgold knows what he's required to do now.
Okay, Mr. Ringgold, if you'll raise your right hand, I'm going to place you under oath. Mr. Ringgold, do you swear that the testimony that you give the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand and just speak up for me so I can hear you, okay? Nice, scoot a little closer if you can. I'm having a hard time hearing. There you go. Just speak up because my court reporter has to actually type down the words that you say in our record. All right, Mr. Ringgold, you've heard what I've stated regarding what I understand the agreement to be on your motion to adjudicate. Mr. White has confirmed that. Is that what you're asking the court to do today, to amend your community supervision conditions to require you to go down to the safety unit for drug rehabilitation?
Sir,
And Mr. Ringgold, has anyone threatened you, forced you, pressured you to make you feel like you had to accept this amendment to your community supervision?
no, sir.
And why do you want to go to safety?
To get my life right and clean.
Okay, and what's your drug of choice?
Methamphetamine,
Methamphetamine. And how long have you been using methamphetamine?
like 20 years.
20 years. Have you ever sought drug treatment before?
Well, a few months back, but it didn't work out very well.
Have you ever been in a long-term drug treatment?
No, sir.
What's motivated you to try to get help?
The time going by, kids growing up.
How many kids do you have?
I have one
You have one boy or girl?
girl,
How old?
15.
15?
Yes, sir.
Very impressionable age for a young girl.
Yes, sir.
It's important for, are you involved in her life?
Yes, sir.
It's very important that if you're going to be involved in her life, that you're a good positive role model for her, right?
Yes, sir.
And I think what you're doing today is something that puts forth a positive role model, understanding that you got a drug addiction, understanding that you can't beat it by yourself, understanding that you need treatment. So I think that's something positive. So I'm glad that you appeared today, and that tells me that you are committed to going to safety and taking advantage of what they're going to try to teach you down there. And so just so you know, I'm sure Mr. White has gone over this with you. He's been practicing a long time, and he's handled a lot of cases, and I'm sure he's already told you that safety is not going to be easy, and it's not a magic wand. You don't go down there and then come back and be and not be an addict anymore. You understand that?
Yes, sir.
You understand it's going to be about education. It's going to be about changing the way you think, changing the way you make decisions, those things. That's the only way that you can manage a drug addiction. You understand that?
Yes, sir.
And so it takes work, it takes accountability, responsibility, and effort when you go to safety. So when you get down there and they're offering you a chance to learn and become educated, I hope you immerse yourself in that and you pick up everything that you can, because when you get back, those are the tools that you're going to need to stay clean and to stay in your daughter's life. And most importantly, to stay out of jail and out of prison, and maybe even stay alive. Okay.
Sir.
All right, we're going to grant the state's motion to withdraw the motion to adjudicate. The court will modify the community supervision conditions of Mr. Ringgold to include safety as a condition of his community supervision. And the court has signed the order on the state. So Mr. Ringgold, sometimes when someone's case is over, I'll say good luck. And so that means, hey, I don't know where you're going in life, and you may need luck. You may need things to happen for you. For you, it's not going to be about luck. It's going to be about work. Okay. So it's going to be about effort. So that's what you're going to need to go down. Luck's not going to get you where you need to go. Okay. So it's time to go to work.
Yes, sir.
All right. Thanks, sir. Go ahead and take Mr. Ringgold into custody. Thank you, Mr. White.
Thank you, sir.
All right, Mr. Schmidt. Oh, you told him to come in. Okay.
I mean, yeah, he left. I called him because he's
Okay.
got this now.
Oh, you did it for him, or maybe you are going for him? Okay. All right, I'm sorry, Mr. Schmidt, who are you ready on?
I've got Kendrick on an arraignment.
It's the on first one. Doesn't have an attorney listed. She must have appointed Mr. Schmidt. All right, this is cause number CR 21357. Come on up, Mr. Irvin. I'm just getting all my affairs in order here. All right, this is State of Texas versus Kendrick. Is it Lyron, Irvin, and Mr. Irvin, you're charged with evading arrest or detention with a vehicle, a third-degree felony, carries a range of punishment of not less than 2 years in prison or more than 10 years in prison if you were to be convicted and sentenced. Mr. Schmidt has been appointed as your attorney on your finding, the court's finding of your indigence for the purposes of counsel. Mr. Schmidt, have you seen the indictment? Go ahead, sir.
I have, Judge, and I've reviewed it with Mr. Irvin. He understands the range of punishment and the charge. His name is correct on the indictment. We waive formal reading and a plea of not guilty has to be set for a pre-trial.
All right, court will find that Mr. Irvin has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record and sets this matter for a pre-trial hearing. Do you have any requested dates, Mr. Schmidt?
I just had the first Tuesday date in December, Judge.
They're gonna give you enough time?
I think so.
Okay. All right, court will set Mr. Irvin in for Tuesday, December 13th at 1:30. All right, Mr. Manning, and I'm sorry, I was unaware that Ms. Abraham had appointed you to Mr. Braylon Hicks.
That's right, Judge. She caught me on my way out.
She's sneaky like that. Is Mr. Hicks in the courtroom? Have you had a chance to look?
Right now.
Have you had a chance to look at the indictment?
No, Judge, I just got information, so I have not had a chance to gather one of those.
Okay, let me display it for you and give you a few minutes.
Judge, Mr. Hicks understands the charge against him. His name is spelled correctly. We've discussed and request a pre-trial setting on this case.
All right, the court will find that Mr. Hicks is indigent for the purposes of Sixth Amendment counsel. The court has appointed the Honorable Jonathan Manning to represent Mr. Hicks. The court will find that he's waived the formal requirements of arraignment, will enter his plea of not guilty into the record, and the court sets Mr. Hicks for pretrial hearing. You want that January 5th or December 15th?
Judge, January 5th will be good.
All right, court sets pretrial hearing January 5th at 1:30, so long as Mr. Hicks is in jail, 9 a.m. if he is on bail. And state, is the murder, I see that Mr. Hicks is being detained on a murder and abandoning, endangering a child. Is there any scheduling of those cases for grand jury or?
Judge, the state is currently holding the abandoning and endangering charge. We do not intend on indicting that at this time. And we have not been formally referred a case on the murder charge as of right now. We are waiting on, I believe there's some final investigation going on, but we hope to get that soon.
All right. Yeah. All right, Mr. Hicks, we'll see you back on January 5th.
Judge, anything else?
You better run.
I'm out of here.
Thank you, sir. Let's see, Mr. Stevens was in the Zoom waiting room, but I do not see him anymore. There he is. There he is. All right, Mr. Stevens, be just a moment and we will bring both of your clients.
All right, Judge, you have Mr. Stevens' clients here.
All right, Mr. Stevens, I'm going to ask that you unmute there.
Yes, sir. You got me?
I do.
All right, Judge.
Ms. Pentler, can you see your attorney, Mr. Stevens?
Yes.
Okay, all right. This is cause number CR 22-283 and 284, State versus Nicole Lynn Pentler, and we're set for pretrial. Mr. Stevens, go ahead.
Judge, I would like to ask for one more pretrial setting. I have visited my client. She's been staying over at the Henderson County Jail. And I fully intended to come and visit with her again before the court appearance this afternoon, but my schedule's been kind of mixed up and I haven't been able to do that. This case, I think, will ultimately work out. I don't think we're going to trial or anything, but I would like another shot at pretrial without it getting to the docket call yet, sir.
And is that, what's the purpose of that? To discuss the evidence with her or just to talk about?
To get with Ms. Housel on the case, Judge, and to discuss more evidence with her, but to get with Ms. Housel. Last time I visited with my client, she told me some information that I need to pass on to Ms. Housel, which I believe may affect the offer that was made.
Any objections from the state?
No, Your Honor.
All right, the court will grant an additional pretrial hearing for Ms. Pentler. Do you want to do that? I'm setting December 1st or 15th.
Let me look here, Judge. Judge, I guess at 15th, I have nothing set. And on the 1st, I'm supposed to be over in Athens again. So if we could do the 15th, sir.
You don't show to be here on the 13th, do you?
Let me check, Judge. No, sir, I do not. I'm there in the morning, but not in the afternoon.
Okay, then we'll set for the 15th at 1:30 for pretrial.
Thank you very much, Your Honor.
Mr. Aguado? All right, this is cause number CR 21-317. State versus Joseph Dan Aguado, and my records reflect, I think Ms. Taberham received a report that Mr. Aguado is number 37 on Terrell State Hospital's list for admission. So he's made quite a move in priority. So
Yes, sir.
so hopefully sooner rather than later at this point, Mr. Aguado will be able to go to the hospital and get the treatment that he needs. So
All right, Your Honor.
any other issues that the court needs to be aware of regarding your client, Mr. Stevens?
Not that I'm aware of, Your Honor. I would like, since I'm not there, I would like to let my client know that I've been in touch with his grandmother, Miss Tinsley, that she's very concerned about him, and I've been keeping her abreast of what's going on. I just want him to know that.
All right. Mr. Aguado, how are you doing?
All right.
You doing all right? Okay, good. Well, if you need anything there at the jail, just let the jail staff know and they'll contact me or they'll contact Mr. Stevens, okay?
Yeah, I'm waiting to go to Terrell State.
We're waiting on Terrell State. That's exactly right. And I think it's going to be pretty soon. It looks like we're almost next up on the list. Okay?
All right.
All right. Let's set Mr. Aguado again for let's look in January, Mr. Stevens.
Sir.
You have I've got January 5th or January 24th.
The 5th would work fine, Your Honor.
Okay. And you can appear via Zoom, for these top hearings. So
Okay, Judge.
if you need to, just let us know. Let us know you're going to be Zooming, so we'll mark it down. So we're going to just set Mr. Aguado for another status on January 5th at 1:30.
Thank you, sir. Appreciate it.
All right. Thank you, Mr. Aguado. We'll see you soon.
All right.
And for the record, cause number CR 21-81, State versus Kristen Laurel Lewis. Mr. Sanders has filed a waiver of arraignment that's been approved by the court. Pretrial has been set December 15th. All right, Mr. Stevens, I believe that's all you have today. Is that correct?
That is correct, Your Honor.
Thank you, sir. Tell Brad we said hello.
I'll do it, and I apologize for jumping off and on Zoom a couple of times today, Judge. It's just a crazy day.
Hey, it's okay. Christmas is coming up. You can make it up to us.
Hey, that'll work. Have a good one, Judge. Thank you, sir.
You're welcome.
Bye.
All right, Deputy Everett, I don't show any other inmates on my list that we haven't attended to. Do you?
Oh, so we're good to go.
All right, then guess we will be adjourned at this time.
Thank you, Your Honor.
You're welcome. Thank you all. You have a good day.